Yeah. So let's start again. Are you ready? Are you ready?
Yes, teacher.
No one responded to me. Okay. So where did we stop last time? We talked about critical thinking skills. Or where did we stop? The broad sense, the narrow. I'm sorry for the internet connection problem, so I was out. Suddenly I couldn't manage. So now I try to see whether I can fix the problem or not. Okay, so I hope everything will be all right from now on. So where did we stop last time? Did we talk about core skills needed for today? Where what is me? Where did we stop last time?
Alo. Nghe hả? Ok. Sao vừa nãy tao nói tao không nghe, cái tao tưởng tao bị hư.
There's a problem with the internet connections. I have just fixed it up. So I hope that you can hear me now, right?
Yes, teacher.
Okay, sorry for the big problem. Because this morning I just thought that I had the first section with you, so I froze my computer downstairs. So the internet connection automatically connected with the downstairs Wi-Fi. But now I bring it up here for the quiet, peaceful environment for teaching. And therefore, another internet connection should be connected if there's some problem with the computer. So it is not automatic. Have to make it and by my friends. So manually, right? So now, where did we stop last time? Where did we stop last time? 4 group skill needed for reasoning study or where? Do you remember anything? Did we stop here? Or we did talk about critical thinking skill, or we already talked about the differentiations, distinguishing between telling.
We move to the predictive writing and associative writing.
Okay, a long way ahead. I remember that last time I gave you this question, didn't I? Last time I gave you this question, didn't I?
Yes, teacher.
Yeah, so now I'd like to hear the answers from you. What is the role of language to lawyers? Can you provide me with some of your ideas? Okay. This is it. Can you start? The ideas. What is the role of English, Vietnamese, French, the role of language to lawyers? Okay. Yeah, I have a list and I mark your speeches, answers, and discussion is counted for your participation marking. You vote. You got any idea?
So, in my opinion, I think that study in the law environment as a lawyer, study in the law environment somehow affect in the vocabulary of that person. And a lawyer need to have the language skill to lawyer, when they are a lawyer, their language somehow be affected, and like in daily speak, they can sometimes unintentionally use legalese or some word that related to law, such as here, hereby, or maybe sometimes use Latin terminologies. So lawyer need language skill to convey from a legal language into the plain language. Like when they working in a firm, they need to use a plain language to explain for their clients the problem in detail. And
So it seems that you are not prepared yourself for this question, right? So I see from your point of view is that the first rule of language to lawyers is the tool of communication tool, right, with their clients, so they can receive the problems that they face, understanding the facts of the case, question them more facts of the case if they want to know more. And then that is the tool. It's just ordinary communication, not special yet, because this way of communication appears in every profession. Even the doctors communicate with their patients. The doctors have to ask the patient certain facts or symptoms that they suffer, right? Headache, stomach ache, or disease, or what is it? Therefore, in the first rule of language to lawyers is the same as the rule of language to other professions. That is the tool communication, ordinary communication, understanding the problems, analyzing the facts, etc. What is the desire, the demands from the client? So that is the first role. What is the second role, the special? Okay. Yep, related to change. Okay, let's go to vaccination. Well, what about the second aspect of language to lawyers? That is quite special, more special than other professions. What is it?
I think to understand the law efficiently.
Providing legal advice, right? The second role of language that how can you convey your knowledge or expertise to clients as well as to opposing lawyers or judges in order to address the demands, the needs of your clients in order to do your work. Okay, so you use the language to convey your knowledge and expertise. You use your language to work. That is a professional tool, the second role of language to lawyers. Can you see the points? Can you see the points?
Yes,
Yeah. I hope the others as well understand the roles of language to lawyers or to people working in any profession in general. But especially for judges, they work mostly with lawyers, right? Rather than the ordinary people. And therefore, they can use more professional language than lawyers. Lawyers have on the one side, they have to contact and communicate with their clients. That is ordinary people. But on the other side, they have to communicate with professional people like opposing lawyers, judges, arbitrators to present the case and to defend the case. And therefore, lawyers in between the two societies, the two communities, it is harder. It is much harder, right? You have to be professional in terms of your knowledge, but as well as very simple in the way that you present your special knowledge to ordinary people. It's not easy. Sometimes I found myself that when I like to present a very in-depth knowledge in terms of criminal law for my students, it's much easier than for very normal people working in the market or somewhere else. Okay. So now we talk about critics of writing and diversities of writing. Now, first of all, I'd like you to turn back to reading materials that are already put available on the website. I wonder whether you review it or not. Now, open it again. There's a case here, like jury. The syllabus is there on the website. There are some cases here. This case, I could like you to read this case. I wonder whether you will read it or not. But this is the case. Bob hires you, right, in the role of Agnes Sally, because Bob wants to sue his neighbor, John. What happened? John's dog has bitten Bob, causing injuries sufficient for Bob to seek treatment. Bob now has medical bills totaling $800, and he wants John to pay. After the initial interview, Agnes Sandy and her crack party will find a law applicable to the situation based on jurisdiction. That is, she will answer the question, what is the law that applies in this case? Then she will research the history of the case in that jurisdiction, which uses the law as a basis for decision. Okay? And then she has to give a legal advice. So now we stop here. Bob is a victim of John's dog. Unfortunately, he was bitten, right? And then his neighbor refuses to reimburse the medical bill, which costs $800. Bob got angry. Why? Because they were neighbors, right? Good neighbors. And now there's a big contrasting views regarding these issues. John considered that Bob illegally stepped into his garden, and the dogs naturally protect their own property. That is trespassing. But he already put the board, said this is a private place, the private property, no trespassing. There was their signal for Bob not to enter the property of John without permission. But because Bob thought they are neighbors, they are close friends, so they can enter into each other's property without specific permissions for each time. And therefore, Papa entered John's property. Because of that, the dogs defense. So therefore, each side has their own views regarding the issues. And now within this moment, Papa would like to take the case more serious. Right? So he hired Agnes Sally to help him. In the role of Agnes, as a lawyer, he has to look at the law applicable to the situation to answer the questions, what is the law that applies? And then she has to inquire into the content of this law. Okay? Then the attorney search the history of cases in that jurisdiction which used at the law as basis for decisions in comparing that case with the client's fact pattern, right? So she will show logically how the client case is likely to fare before a judge. Okay, so that is the work of the attorney. And then the attorney can easily determine Pop's chances of prevailing in court against John. And keep in mind that John's attorney will prepare a similar memoir based on the same court cases, which will be more or less identical in substance to that attorney Sully prepares. Okay, so that is your work. And now, after the conversation with Bob, understanding the requirements of Pop's, attorney Sully have to prepare the legal advice to Pop's, whether he will win the case or what would happen if the rules is interpreted into his circumstances. Okay, so he produced his legal advices in terms of a legal memorandum. See the word memorandum. He presents his legal advices in the form of a memorandum and sent it to Pop. So, well, when Pop have seen the legal advices, the outcome of the case that attorney Sully advised to you, Bob came to see John and would like to ask John again at the last chance whether he could pay the bill or not. But John again refused to pay. And then Bob decided to ask attorney Sully to go further, to apply a petition to the court to deal with the case. Bob hired attorney Sully for the second step, that is defending him in front of the court. The first step, Bob requires attorney Sully to help him with legal advices. Based on that good results, we'd like to go further. And then attorney Sully presents in front of the court, and she has to put with her arguments to protect Pop's rights. He has to submit another document to the court to persuade the court regarding voting in favor of Pop's. Okay, so now I would like to ask you 3 questions. You understand the background, the story. 3 questions. First, why attorney Sully has to produce a memorandum, has to write down a memorandum when giving advices to Bob? Is it possible for attorney Sully to invite Bob into her office, made a conversation, telling Bob his situation and predicted outcome? That's it. And Bob come back home. She shouldn't or she mustn't write down the memorandum, because writing down your ideas is taking a lot of time. That is time consuming, effort consuming, and that is a lot of work. My job of attorney Sully just invites Bob into his office and have a conversation, giving legal advice and then receive money. That's it. But she must write down a memorandum containing legal advices. Why? And even regarding the second step, proceeding under court, is in most of the cases requires written submission from the parties regarding their claims, regarding their arguments, why writing again. Although later on they have the oral hearing. First of all, they must submit their written documents or arguments. Why writing is always my first section. Why should our work require a lot of writing? The second question, can you compare the differences in the styles of the first paper, a memorandum that Artemis presented to the top, that document, and the second document that Artemis submitted to the court to defend Pop's case? What are differences? Is there any? And if yes, what is it, or what are the differences between these two types of documents or two documents? So, first of all, two questions, and when you address it, I will go to the third one. Why we should write down our legal advices? Why we should write down our legal arguments when we defend or we just bring the case in front of court? Why should we write down all the time? Any idea?
Yes. Yes, can you hear me?
Yeah, I can hear you very well.
Yes. I think the lawyer should give the legal advice because that make the process easier, or the lawyer as well as the client facing have ability to face a legal issue. Let's talk and resolve.
Why let's talk? I couldn't understand your point. Why writing down things much the legal issue? Let's talk. Talk or not talk is the nature of that issue. By writing down or by speaking it up cannot reduce or decrease the level of toughness of those issues. I don't believe it.
Because I think when the lawyer gives their legal advice, they can communicate with their lawyer clients.
Yeah, by speaking up, they also be able to communicate with their clients. There's no interruptions at all. They can come for a cup of tea, talking to each other. If the client has some more questions, they can raise those still vague in his mind to their attorney. It's much more direct and straightforward. I couldn't see the point. Sorry.
I can say that legal advice forms an agreement between the lawyer and their clients are based on a particular matter that the client is experiencing.
Good. That is a good point, Ian. Legal advices, according to Ian, that attorney solely presented to Paul is the performance of the contracts. Legal advising contracts between attorney solely and Paul. Right. That is the performance of the contract. And that is the showing of the work that actually have been done, right? That's right. But why should it be written for? Why should it be written for? I could like to ask some more ideas about it.
Can I answer this question?
Yeah.
Well, I think that everything should be made in writing in order to serve as record for the litigation.
Yep. Evidence, right? Asking solely like to receive money from Pop. But then Pop said that there's no product at all. You didn't perform your contract. Yes, I did orally, but you need some of the evidence, the records of evidence of proof clearly about your performance of the contracts. So written evidence is one of the very good evidence for you to prove that you have performed the contract. And then the other side also need to perform their payments. Yes, that is a kind of protecting the lawyers, showing their work, so they deserve the money. Okay, what else? Can Bob memorize everything that Attorney Sally told you? Can you yourself put yourself in the position of the client and you saw your attorney talk for 1 hour, 2 hours regarding your cases? Could you memorize everything that your attorney told you? Yes or no? Yes or no? Good night.
I think I can do it. Yeah. And in my opinion, another point is writing down the everything in written can assist the client and the attorney to ensure that the information they are provided or provided by the client can is not contradictory, because when the client provide the information, it can change in some time. The detail of its information can change. And the memories of the client. And the legal advice of the lawyer is to be in reason to make sure that there is not a
misunderstanding of the legal advice, right? Okay. Thank you, May. That's right. Because of the limitations of memorizing capacity, right? We cannot, even me, I cannot memorize everything that the others tell me for 1 hour at least, right? Because we cannot memorize everything at first. And secondly, maybe Pop wrongly understand attorney words. Actually, Sally tell Pop this. but Pop understand in another way. So then later on, Bob claims back his attorney. He claims back that his attorney provided him with wrongful advice. So here, you see a lot of problems. First of all, Pop cannot memorize every detail of legal advices when Pop would like to refer back. So therefore, a piece of writing containing all the legal advices from the attorney will be very, very helpful to him. Very helpful to his memory. Secondly, if he wrongfully understands the legal advices, the written piece of documents from lawyers is still there. And this piece of writing will serve as an evidence again to protect the lawyer, right? And to correct Pop's thinking. And therefore, you see, lawyers need, in terms of the lawyers' protections themselves, that they need to provide their legal advices in form of writing. First, serving as a record of evidence of their work. Second, serve the quality of their advice. They are responsible for their legal advices. And you know that if their legal advices leads to some negative consequences, they are responsible for their advices. You see, even some lawyers review a contract in terms of very multinational companies. Those companies are so huge. Contracts can lead to the loss of millions of dollars, a lot of money. And therefore, they spend money with you, they pay you for your legal advices to prevent them from risk. You couldn't do that, so they charge you of the bad results that they have to suffer. You know that? And their lawyers have to buy insurance for their legal profession as well. So therefore, in terms of the second aspect, the lawyer need to provide the legal advices in the form of writing to prove with the clients that you wrongly understand my advices. Here are my advices. Okay? So in terms of the lawyers, they need to write down their legal advices. From the aspect of the clients, they also need the legal advices to be written down because they cannot memorize everything and they should use them later on for references. That is the two aspects, views of the need of writing and why writing is so often if you decided to become a lawyer. Okay, so now regarding two pieces of writing, the first one is sent out to Pops and the second one is sent out to the judge. Can you see any differences in their style, their purposes, their language? Okay, so can you see anything? Huỳnh Nga. Huỳnh Nga. Huỳnh Nga is not here. Hoa Thi.
Yes, me. Can you repeat the question?
The questions. Do you remember that, first of all, the attorney Sally have to send out a paper containing her legal advices to Pop's case, right? Forwarded to Pop. And Pop hired the attorney Sally to go further, to bring his case to the court. And attorney Sally have to prepare the second document sending out to the judge in order to defend Pop's rights.
Yeah.
Can you see differences between these two documents?
The first difference between these documents may be regarding to the language which the lawyer used, because if the lawyer writes to Bob, he is not a legal, he is not working in legal field, so the lawyer should use the ordinary word, not legalese or legal.
Right. Good.
But on the other hand, when the lawyer file the document to the church, they should use other they should use a legal term or legalese in the way they convey to the idea, maybe more professional and explicit to the church, because the target audience is the church, the professional in legal field.
Okay, so the first difference is in terms of language. Okay, the second one. Quang Vinh. Quang Minh. Quang Minh. Louder, Quang Minh. I see you to turn on the microphone, but you didn't. No, not yet, Minh. I couldn't hear you. There is some problem. I see you to turn on your microphone already, but I couldn't hear you. So just let's to ask Quang Vinh. Quang Vinh. Is Quang Vinh there? Okay. Cô đang trên lớp Duy ơi, lát cô gọi lại nha. Chứ phải sau 12 giờ, cô dạy 12 giờ. Okay. So Quang Vinh, can you speak up? No one answer me. Okay, so I would like to ask Hoàng Yến. Hoàng Yến.
Yes.
You see another difference. Can you see the title here? predictive writing and persuasive writing, two different styles of writing, which is very popular in legal profession. And do you think that these two documents presenting these two different styles
Let me think. In my opinion, persuasive writing is a kind of writing that is more neutral, while predictive writing is refers to more predictable.
Okay, so now I could like you, because you are not the law student, so you are not familiar much with the legal issues. So now I could like to analyze it for you. The second one, just present not neutral, because the document sending out to the judge, presenting the arguments that protect Pop's rights. So there must be a persuasive writing. It's not neutral at all. If the letters sending out to the court, presenting both the strengths and weaknesses of Pops cannot have a chance to win because it's presenting Pop weakness. And therefore, you see, the document, the second document is presenting the persuasive writing. It's just one approach, one side approach. It approach to protecting Pop's rights. But the first letter that the attorney Sally sending out to Pop, you see, attorney Sally have to point out both strengths and weaknesses of Pop's case. It is a neutral analysis. Pops, here is your fault. You're entering John's property, land without permission. That is your fault. Okay? Pop, you have a mistake. But on another way, then even when you wrongfully trespassing their land, the author, the owner of the land cannot injure your life and your health. And therefore, it's another fault from the owner. However, because of part of your fault, maybe the money that you receive from John, not whole of the bill, but part of it, depending on the ratio between the phones of each size. For example, you have to analyze the case, both strengths and weaknesses of Pops in order for Pops to understand the truth, for Pops to understand the possible outcomes if we bring the case further into the judge. If not, if he just shows all of the Pop's strength and he believes that he win the case, but later on, the other opposing lawyer, the attorney of John, pointed out all of the weaknesses of Pops, and he was astonished of that ideas. He was surprised because previously you didn't tell him any weaknesses from his side. So turned out the case were uncomfortable for him, right? Therefore, the first document, you have to provide a very neutral analysis, both strengths and weaknesses, pros and cons, advantages and disadvantages, everything in terms of his case for him to understand. And then maybe if the case is not in favor of himself, you can advise him. So from my research, in terms of the rules in previous presidents, I could advise you to agree with John that you received half of the bill. Maybe you give advice. Whether he agrees or not, it is his turn. Pop decision, not your decision. Okay, his case, not your case. You just functions as an advisor. Okay, not a decision-making person. So therefore, you see two documents presenting two styles of writing. Further purposes, they are different. In the first documents, it predicts the outcome if you bring the case to the courtroom. And therefore, the first purpose of predictive writing is to advise your clients regarding the legal issues concerned. Okay. Another purpose. Now I go to that particular case, Pop's one. Pop decided to bring his case into the courtroom. And then he wondered, how long does it take? How many steps has it passed through? What should he do at the courtroom? Okay, so what should he say? Or what is his rights and obligations when he presents himself in front of the judge? A lot of questions happen to Pop because this is his first time dealing with such kind of work. So therefore, you have to advise him again. How long does it take? How many steps? What happened? And what is his rights and obligations? The procedures of the hearing, okay? And the procedures of the court in dealing with such kind of civil case. Furthermore, what should Bob prepare for winning the case? What evidences he should collect? Okay. What demands he should present? What claims he should present? So, the second purpose of predictive writing is to plan litigation. Attorney Sally has to present all of these things to Pop. Procedures and preparations for proceedings for litigation. And therefore, the second purpose is to plan litigation. And these kind of documents are just predictive writing. We predict only, okay? Predict the outcome, predict the process, predict the procedures, okay? These documents are dealt with the clients, okay? Dealt with the clients. And therefore, the language should be quite simple, ordinary. Previously mentioned by Pui Mai already. Okay, the purposes are here. Is it? And the legal memorandum, you've seen the word memoranda, plural memorandum. This is the most common type of predictive legal analysis. This is often provided to our clients. Okay, and sometimes it includes the client's letter. Why? Because different facts leads to different rules to be applied. Okay, different facts. For example, that is the Pop's facts. I take another case, Michael case. Michael has bought an apartment and it has recently launched. He received a new apartment with an excitement feeling, exciting very much. Therefore, he decided that everything in his new apartment has to be originally new. Therefore, although he has another washing machine, you know, washing machine, do you know that? Ngọc Yến, do you know washing machine? In Vietnamese, what is it?
Yes, it's the Vietnamese meaning máy giặt.
Yeah, he had another one, but he decided to buy the new one. He came to the shop, signed a contract, purchased one original new one, and that machine was launched at his new apartment in the afternoon of the same day. But unfortunately, something wrong. The water van of that machine didn't function properly, malfunction. And therefore, the whole machine didn't function as well. The technicians people told Michael that no problem. It is just the water van. And we just replace this water van and the machine will work and functions properly. Don't worry. After 2 hours, we come back to the shop, take a new water van, and we come back and we replace it for you. It will function properly. But Michael determined that everything be perfect, and therefore refused the replacement of the water van. He asked for the replacement of the whole machine instead. The technicians refused his demand, his request. They said that we make sure that we guarantee the proper functions of the machine, but we don't need to replace the whole machine as you required us. Michael disagreed, and he continued to complain with the manager of the custom service department. He complains with the manager of that customer service department. But the managers address the same answers. We just replace the water van for you, Michael. That will be all right. Michael insists that he take his case to the court. He rented or asked for the help of his attorney. And you see differences in facts of Pop case and differences in the facts of Michael case will lead to different rules to be applied. Can you see the point? Can you understand the point? Different facts lead to different rules. Do you see the point, Bảo Ly? Bảo Ly. Okay, so I have to make an announcement. If I call the name of someone in the list of participants, but those who didn't appear, I will mark a minus. Even ones who didn't attend the class without permission, didn't ask me for permission, I mark a minus. And when you have one positive marking, it's just equal to one minus. Well, when you cancel all of the minus marking, delete all of them, you will have a chance to have the positive mark, the plus marking. Cô thông báo lại về cách chấm điểm tham gia lớp học như sau. Mỗi lần các em phát biểu tốt, đúng ý, cô cho các em một dấu cộng. Phát biểu như không tốt nhưng mà nó tạm được, có ý, một dấu chấm. Không có ý gì hết, không dấu nào. Nhưng khi cô đã gọi ở trên lớp hoặc cô nhìn danh sách lớp tham gia với danh sách lớp học, ai không học, cô cho một dấu trừ, nếu không xin phép trước. Gọi tên mà không có mặt, một dấu trừ. Chừng nào gỡ hết trừ, lên dấu cộng. Và bắt đầu từ dấu cộng, các em mới có điểm để các em qua được cái điểm tham gia môn học. Ok, clear? Is it clear?
Yes, teacher. Yes.
Okay. How many students are there in our class? Thảo Linh. Khánh Linh.
In this time or the
No, in total, not this time, in total. For this subject, legal reasoning. Khánh Linh probably knows. Khánh Linh, where are you?
Yes, Miss.
So how many students registered for legal reasoning together with me? How many?
I didn't know the exact number. Around 20 students.
Around 20, must be more because here in our classroom already 24. Maybe someone registered or entered into the class with 2 accounts, but more than 20, I suppose, right? Okay. But
we have 32 students who registered this. Yeah.
But here we have only around 24 students appear. A lot of students are disappeared here, and even some accounts exist, like Quang Vinh, but he didn't answer me at all. Bảo Ly, she also didn't answer me at all. So some of you access into the account but didn't appear in the classroom. So you see, different cases, different facts. Different facts lead to different rules to be applied. And therefore, why in some documents, predictive writing, we include our client letter. Because our clients gives us the facts. We didn't know the facts. What happened? We received from them. And therefore, in such cases, we include their clients in order to say that our legal advices are based on the facts of their case, of facts that they give us. The second point is that the same case, but there are different questions, different demands, different interests, right? Some people would like to ask about the money. The other client would like to ask about their rights and obligations. And therefore, different interests leads us to different advices. It depends on the questions from our clients. And therefore, sometimes you should include the client's letter in order to make clear that your legal advices address their questions and based on the facts that they gave us. Okay. And some of the memorandum not only provide with a neutral analysis, but some attorneys go further with their legal opinion. What should you choose the options of the ways going forward? There are this first option, this is the second option, and this is the third option. So which could be the best one for your clients? So you can further go with that and advise them to choose the right way ahead. Okay. What are the functions of predictive writing? First of all, it predicts the outcome of the legal questions. So for example, in Michael's case, you have to predict whether he is entitled with the replacement of the new one of the washing machine, or he doesn't have that right. In Pop's case, you have to predict whether the court will require John to repay the bill of $800 to Pop. Okay, so you predict the outcome of the legal questions. In Pop's case, the legal question is the reimbursement of the medical bill. But in Michael's case, it is the questions of guaranteeing and the replacement of the original new one. Okay, different questions. How can you predict this outcome? If this brings to the judge, it could be that. How can you predict it? How? Hồng Ngọc. Yep. Right, exactly. Thank you, Hồng Ngọc. Very good answer. Right. Analyzing the rules. Analyzing the facts first, and then analyzing the rules. The rules is called here authorities. The rules and precedents, right? Written rules of case law, etc. Good. The second one is that to explain. You said that this is the outcome, but you have to explain and apply the authorities, okay? And then to give your advice or recommendations. As I already mentioned to you, the piece of writing serves as a record of the research have been done by the lawyers, right? Giving the legal questions, giving the addresses to the legal questions. Okay, that is the first point. Now we come to the second point. What time is the end of this section? 10 past 10 or 20 past 10? When this section ends. Now, what time is this section end, this lecture? 10 past 10 or 20 past 10?
10:20 is end this session.
Okay, 10, 20, good. Okay, so persuasive writing. Well, this is typically the document sending to the courts, maybe also the document sending to the opposing attorney, right? The attorney of John's side. In order to persuade the authorized people to decide a case. So this is argues for one approach only, not a neutral prediction anymore, okay? So one approach in order to solve the case. So therefore, it's normally structured into the form of an argument. And you know that an argument, the legal argument, is the most rhetorically stylized, comprehensive, professional, evidence equipped, right? A lot of requirements if you would like to frame or to structure your argument. And therefore, persuasive writing is having another function. What is it? It persuades a deciding authority to favorably decide the disputes, the conflicts, the disagreements in the favor of your clients. So here I mentioned that this type of document is mostly submitted to judges, but not only judges. Who else? What do you think? Huyền Nhi. Turn on your microphone louder, Huyền Nhi. Huyền Nhi, I couldn't hear you. Okay, sounds now. Huyền Nhi.
Yes.
Go ahead.
My
There it is.
internet.
Go ahead, please.
Can you repeat the questions? My internet connection is not good, so I just listen the rest of the questions and
Okay.
in the
Okay, so persuasive writing is mostly used to submit to judge, who is a deciding authority. But in certain cases, persuasive writing is also be able to submit to older people. Who are they? And why? You need to submit this kind of persuasive writing to those people. Okay, Huyền Nhi's connection has some problem. So now we turn on to another person's who internet connection is much better. Linh Nguyễn. Khánh Linh, another person. Linh Nguyễn is another person, isn't it?
Yes, can you hear me?
Yeah, what is your full name?
My full name is Kim Linh.
Kim Linh. Okay, Kim Linh.
So, about your questions, I think the persuasive writing, they have own opinion in that. So, not just the litigation and litigator in this case can read to get the point of the writer. I think so.
Yeah. But it's not from the reader's side, the reader views. For us, sometimes we would like to read these kind of arguments in order to learn experience. But from the side of the attorneys, the lawyers in such a case, why he has to send her or his persuasive writing to arbitrator? Why they have to write persuasive writing to sending out to the media, to mediator, right? Because you see, sometimes you can choose between using the judge, the court to decide the case, or you can submit your case to the arbitration. Gửi cái vụ kiện của mình ra cơ quan trọng tài để họ giải quyết, right? Therefore, you have to persuade arbitrators rather than judges. So in such cases, you have to send your persuasive writing to arbitrators. And in some cases, you choose not to submit your case to the judge because that will be a public announcement of your reputation. You are involved of conflicts. You don't want that. So would like to go to mediator, người hòa giải. Okay. So conciliator. Yeah. Some cases they don't want to have, for example, Pop and John. They are neighbors. They used to be good friends. They just misunderstand each other from this point because John loves his dog. John believes that his dog has no fault. But Pops loves to see John's talking to him so that trespass his location. So therefore, between them, there is still a goodwill of healing the neighborhood, keeping good relationships for the future. And therefore, they may choose not to go to the judge or arbitrator for a very complicated things. They could prefer to go to the mediator who understand their relationship, who understand their wills, who can decide a case clearly, but help them to maintain the good neighborhood with each other. So they may go to mediator, you see? And therefore, each side needs to submit the persuasive writing to the mediator so that the mediator can see the points of the case from each side. And sometimes the media is involved. You see, like Phương Thảo and Anh Vũ, Highland coffee cases, not Highland, Cafe Trung Nguyên, right? Case. In such a case, the media is involved and it persuades the attitudes or the views. It may strongly influence the attitudes of the deciding authority involved. And therefore, they could like to persuade the media. Or even they could like to earn the support from the media for their future career after the divorce. And therefore, they could like to submit the persuasive writing to the media to lead them into their way. Therefore, the functions of persuasive writing is not to persuade a deciding authority, including judges, arbitrators, but sometimes to persuade the others who are mediators or mediators or clients, suppliers, some people involved in the relationship with the clients. Furthermore, sometimes persuasive writing is very needed to submit to the disputes opposing party, to let them see their faults, to let them see their obligations, right? So therefore, if you can persuade the dispute opposing party, it could be great. Okay, so these are two styles of writing which are very popular in legal profession. You know, that's very, very popular. All the time you have to write down these most of the styles. So now I would like to stop the lecture here, and I will see you at 10:30. Right, we will start the next section. I will just stop here. See you at 10:30.